y distinguidos representantes del Estado argentino. Con la venia de este tribunal comparecimos hoy en representación de la memoria del doctor
No, puso micrófono. Su micrófono no.
Este caso trasciende la historia individual del hombre justamente removido de su cargo.
A man who was removed from his position.
Deliberado, artero y calculado contra la
This is
independencia.
calculated against the independent judicial independence of the Republic of Argentina. This affects the rule of law in the entire region. In fact, this process needs to be understood in a regional context, evidenced by 75% of international were in the same period, and of arbitrary judges such as in Peru, Venezuela, Peru. They show a structural pattern to attack judicial. Ms. Moliné O'Connor was named as the judge of the Supreme Court in 1990, and he exercised his position until 1993. That moment, in 2003, excuse me. At that moment, Mr. Petitioner ordered the Congress to remove the judges in the Supreme Court. Then his wife, Miss Cristina Fernandez de Kirchner, then she started the impeachment process against my father. The lower chamber, responding to an official of the government, they used the reason for bad performance to charge my father, and then they ordered the removal of my father. This having lack of guarantees. This happened during the commission for more than 20 years. To there we have to add as he was revoked. The senator, his retirement for 1998, revoking his rights that he had already acquired with the persecution. And Dr. Moliné O'Connor, he suffered a terminal illness over time. So that's why his children and his wife comes in before the court to remember him and to try to have justice. We wish to, in our ASAP and in report on human rights, the Commission in its report concludes that the Argentine state violates judicial independence and to have an impartial authority within a reasonable term, to violate the principle of legality, the political protection, and the legal protection in 8.1, 9, 23, and 25.1 in the American Convention on Human Rights. The violation to the principle of judicial independence, poor performance. The Commission, as well as us, the representatives, have sustained that the removal of Dr. Moliné O'Connor is a serious violation of independent judicial independence, stability in the position, and the motivation that are consecrated in Article 9 of the Convention. There's a vague cause of poor performance in Article 53 of the National Argentinian Constitution. As the Commission pointed out, this case was never developed by a special law. There's a lot of discretion given to the accuser. It says that the magistrates need to know the parameters of their behavior, and at the moment, unacceptable. Albert Camus says the biggest of the storms in in one's hand is to be judged without a law. A cause for the removal of judges cannot depend on the interpretation of a political body, but a defined and clear definition that ensures legal security. The states in these 22 years did not say that what was the human cause poor performance. An example of this is the response of the state before the Inter-American Commission in 2007, and the Ministry of Justice, the Camera of Senators, and the lower chamber, and the Ministry of Foreign Affairs. These four bodies, after hundreds of pages, the state could only define that poor performance was when each case the Congress defines what it is. I repeat myself: poor in performance in each is for every case what the Congress resolves it is. It referred to poor performance to the legal good backed by the political cause, and that general interest of the society, the protection of public interests. More serious even is that in the Argentinian state, through the Ministry of Justice, that the real cause of removal was the Smith and the province of San Luis, that had to do with the immobilization of all the bank deposits and the specification of visas, foreign visas in Argentina, which the court determined the causes, the right of property, which is supported by the Constitution, Article 7, and they violated the right of property in Argentina, and in a short period of time, Dr. Vasquez, who was a witness in person, told us how the President Kirchner, when the court said it was going to, he called Julio Nazareno and said, if you take out the judgment, we'll begin the impeachment process. And then Dr. Nazareno said that the judgment was already signed, and during the afternoon, the President, Dr. Kirchner, started through the national network a speech where he started the impeachment proceeding. And this Argentine confesses that his act in the mayor case was fraudulent. This, which was accredited by official documents, confirms as a confession of the Chief of Staff, Alberto Fernandez, in a televised interview in 2004. It was also indicated in the writ. This is transferring into a institutional falsehood because of its act of a judgment. The real motive was to violate the right of property in Argentina. The sentence was absolute. Our father directed his defense to apparent causes without looking at the real cause. He fought against ghosts and phantoms. What was the figure that made up poor performance? In this year, the fact that caused performance was never clarified, and it would to declare and recur the judgment of an arbitration court not applicable. Enrique Palacios came, who's from Argentina. He added in the writ that it concluded from the mayor case. It was treated as extraordinary, a decision of the arbitration court of public works. You only see in this trial from the point of view of the arbitration, there was no judicial cause. The election of the administrative procedure, it was important to have the result of the judicial result. It stresses that the legal standard regarding judges followed by this honorable court is established in Petitioner against Honduras, and which conforming with the principle of maximum penalty, it confirms that the removal of a judge it only needs to be for behavior that is poor, from actions of poor performance of incumbent tenants. Judicial independence requires that the designation of judges be the last ratio in legal matters. In accordance with this, the Commission in its report, the report on Moliné O'Connor was impeccable, following the classical route of Supreme Court. We said this in 27 years. There's no cause, and a serious one, for his removal. The legal standard, according to this legal standard established by this court, Dr. Moliné O'Connor was removed for his criteria and his legal criteria removed from as a magistrate of the Supreme Court. Without prejudice to this, the Senate and the lower chamber evaluated their judgments, their foundations, and their consequences, which is an attack direct and to immunity of judges for giving their opinions. The state affirms that the removal was confirmed because they're a millionaire credit to the state to have legitimized a fraudulent administrative proceeding, having applied the control of constitutionality. This is not poor performance, but is the evaluation of a legal criteria. The argument of the state that its decisions were valid and reasonable and motivated is not sustained, since the motive was concentrated on the content of its judgments. This is something that prevented the judicial independence, and that the vague cause produced removal for legal arguments. The essence of the violation and the motivation is, among other matters, that the Commission concluded that the destitution was not duly sustained, since no argument was identified that would explain that the foundations of law used by Moliné O'Connor was a serious violation that justified his removal. It was legal explanations did not justify how this was poor performance. In the framework of the impeachment under jurisprudence of the Supreme Court, no analysis was received from the lower chamber or from the Senate. We point out that nor the Senate or the Supreme Court of the Argentine nature, what was the human action that constituted poor performance? This is the reality of the decision. The argument that the Senate, as a organized body that expresses its decision by concurrence of votes, is rejected by us, because this way of acting with a mere count of the vote of senators just raising their hands without any foundation shows the violation of Articles 8 and 25 of the Convention. There is no wording that describes the actions, or no wording that analyzes the defenses, or any wording that describes or analyzes the evidence offered, and fundamentally the causes of position of Dr. Moliné O'Connor. There was just a judge and a high court of a country. That proves that this was a political decision. The Inter-American Court of Human Rights, when you're talking about disciplinary sanctions, the motive would be even greater. So the disciplinary control hasn't objected to evaluate the behavior and the action of a judge as a public entity, and can analyze the seriousness of the behavior and the sanction. López Gómez said against Honduras in 2015. The commission on its behalf concluded that the decision based on a legal decision and a vague cause without showing an arbitrary position shows this laws that were violated in due diligence. The absence of impartiality, the impeachment, because of its mixed nature, legal and political, it requires a high degree of due diligence, but the Argentinian state violated the violation of the right of press and to be heard. Terms for the defense were extended too long and to produce evidence against Dr. Moliné, and to say that the terms to be indefinite terms, and these guarantees were only formal. It can be shown. The lack of impartiality. In this process, authorities participated in a position that were previously taken from the point of view of the government and the executive branch. Violation to the right of legal protection. The lack of this political position was not sufficiently reviewed. Dr. Moliné O'Connor did not have true access to justice to apply arbitrarily. This lacked the arbitrary nature became intact as a foundation for the not only for the value of the cause, but to see legal criteria, but in a crucial way for the absence of a clear motive to explain why the legal decisions constituted poor performance, a deficiency that the system of internal legal matters did not correct, leaving there was the gap there with judicial independence and due diligence. This is not a minor thing. This is open door of political persecution to judges, and which also affects the entire judicial branch. Courts can no longer be impartial. This was limited and deficient. The Supreme Court, as indicated by the Commission, declined its competency to evaluate if there was a legal backing, sufficient legal backing. When formal aspects of due diligence were verified, the merits to see if a judge could be removed by this way was not determined. The Supreme Court of Justice to limit its review of Juan Molina without a true access to justice. This, excellent judges, it was not an effective resource as the convention required. In this case, the Supreme Court rejected the resource in June of 2000, for declaring that the cases justice cannot be given to the case. The final judgment was based on political reasons, and that people needed to evaluate within the framework of the Constitution, within the framework of discretionary measures, how it applied with the national Constitution. This has to do with political reasons. The Supreme Court configures the removal as a political act of the Congress without reviewing the merits and valence guarantees of 8 and 25 of the Convention. The petitioner found him in a blocked roadway, and it eliminates the rule of law. It ignores the needs and allowing political arbitrary decisions. Palacios sees this judgment and defines this as unacceptable, because taking into account that the actions of Molina O'Connor, where is the poor performance shown? So this legal expert took out the independence of the judges regarding the content of the judgments, and that have been substituted by discretionary actions favored by the Senate against the removal of a judge, the parameters of mere convenience. So here, what is going on in Argentina, and in these cases, everything is in the hands of legislators and nothing is reviewable. Violation to the right of property and Social Security. Legal removal of Molina O'Connor had direct consequences in his law rights, property, regarding property. And
through Resolution 255/8 had a direct consequence, and this is backed by Article 24/18 that denies the benefit for persons with poor performance. However, if this was arbitrary and illegal, based on judicial opinions and or political reasons, the premise to deny the pension is invalid. The negation of this pension is a violation derived from the judicial proceeding, and through resolution from 2024, 21 years later, this was admitted. So it ignored the report number 3023 from the Commission, knowing that this report was added to the file, highlighting the numerous violation to Article 25 of the Commission. It's highlighted. So it is evident the responsibility of the Argentine government, and there is a need to repair this damage and to restitute the pension. Reparation, it is an act of comprehensive justice. Honorable Court, the government from Kirchner was a machinery, a power machinery that used all the institutional resources to commit crimes, damaging institutions, personal interests, and in this case, a trial that was a fraud that derived in a coup. It was a treason to the country. So let's remember that former President Cristina Kirchner, together with her officers, they are now in jail. So after everything I have mentioned, we ask that the Argentinian state, repair in a proportional way, and that the sanction should be severe and exemplary in order to dissuade other cases. However, this comparison with massacres is not proper. It's not correct. The alleged victim was removed, and what finally occurred, the President Javier Milei mentioned that it was all the problems faced by the victim and the death of our brother are terrible damages suffered. But the removal of a judge from the Supreme Court and the damage of his reputation, his economical stability, and his life project, and all the threats he received occur in extreme damages. These practices destroy institutions and make the people even poorer. In the last 20 years, we can include Argentina in that list. We demand the restoration of all the rights, including the restitution of his pension, the salaries, and we demand the court the witness report that was included so that the salary, the pension, and the retirement payment are all included. Any other mathematical calculation will generate poverty in this situation because Argentina is suffering inflation and our mother will go through extreme situations. After a quarter of a century, the effort of the petitioner, his life and the life of our dearest brother doesn't end in we are trying to find that the people responsible, there are consequences for this. Regarding the pension of our mother, we request for this to be returned to her as soon as possible. Indemnization for damage of everything that was suffered by this injustice. The reimbursement of all the costs at the national and international level. We believe that this case is an opportunity that this honorable court reaffirms that judges cannot be moved as fundamental pillars of the nation. This message will be important to show that politics shouldn't meddle in justice. And so we require the publication of the ruling, and we also request that as guarantee of no repetition, the norms are adapted to international norms. In the name of and the memory of Dr. Moliné O'Connor, we request this honorable court to declare international the responsible as the Argentinian state. Thank you very much. Thank you so much to the representatives of the alleged victim. Right now we will hear the closing arguments of the state. Good afternoon, judges, members of the Honorable Court. Greetings to the representatives of the members of the Commission on Human Rights.
Señora Presidenta, y creo que es de suma importancia ponerlo en resalto. Una vez más nos encontramos ante esta
I think it is important
presuntas violaciones a los derechos humanos y a la Convención Americana sobre Derechos Humanos que fueron denunciados hace cerca de 22 años atrás, cuando el 17 de noviembre del 2013 el señor Eduardo Moliné hoy fallecido interpuso una petición de la Comisión Interamericana. Será recién 15 años después que la Comisión decidió aplicar la resolución 1/16
15 years later,
para acumular las cuestiones de admisibilidad y fondo con el objeto de reducir el atraso procesal. 15 años después, cuando la lista ya se encuentra en funciones obligadas de ser resuelta. Y esto, si esto fuera poco agravio para la legitimidad del sistema interamericano, el hecho de las presuntas víctimas a una decisión tomada y al Estado de Derecho de que el proceso internacional se desarrolle dentro de un plazo razonable, la Comisión Interamericana se tomó 5 años más para resolverlo. 22 años para que este asunto venga a ser conocido por este tribunal en de la fecha. Con el respeto debido a la Comisión, que hoy la tenemos con una representación de estimadas colegas a ningún comisionado, y alejado de todo criterio de racionalidad y que afecta a una parte que pone en juego la credibilidad misma del sistema, estas demoras se siguen perpetuando. Pero hay más. Señora Presidenta, señores jueces, como consta en las actuaciones que este tribunal tiene bajo consideración, el informe de admisibilidad y fondo se adoptó el 16 de marzo de 2023 y fue mantenido literalmente en la clandestinidad más absoluta, sin que ni las presuntas víctimas hayan sido notificadas del mismo, que obviamente el Estado, hasta el 20 de agosto de 2024, es decir, casi un año y medio después de haber sido aprobado por la Comisión. Esto es un hecho gravísimo, señora Presidenta. Bajo qué facultades convencionales, estatutarias o reglamentarias, la Comisión tiene la potestad de decidir arbitrariamente cuándo es el momento oportuno para notificar su decisión. ¿No sería acaso de inmediato, como corresponde a la judicial, como corresponde a la pacífica práctica de cualquier tribunal y cualquier organismo internacional de protección de derechos humanos? Porque si bien el artículo 51 de la Convención establece un plazo de 3 meses por el caso de la notificación del informe para que el caso pueda ser conocido por esta Corte, ¿puede arbitrariamente la Corte decidir a su gusto conveniencia y pasando por delante del derecho de las partes cuándo va a formalizar esa notificación, esa decisión? ¿Qué clase de debido proceso internacional es ese? Francamente escandalosa la situación. Más aún, no puede dejar de notarse que los hechos que hoy se juzgan ocurrieron durante el gobierno del presidente Petitioner. Idéntico signo ideológico al que gobernaba cuando la decisión de admisibilidad y fondo fue adoptada. ¿Será acaso por hipótesis que ha habido una intencionalidad política por parte de la Comisión para que la anterior administración de gobierno en mi país no fuera la que sea sometida a la obligación de dar cuenta a esta Corte de actos de anteriores gobiernos de signo y orientación política? No se me escapa, y volveré sobre esto, señora Presidenta, el principio de continuidad jurídica de los Estados, pero no deja de llamar la atención al Estado argentino la conducta de la Comisión, que dista de ser respetuosa con los altos valores que debe defender y con los mandatos derivados de la Carta de la Organización de Estados Americanos y la Convención Americana. Sería indispensable, en consecuencia, y así lo dejamos expresamente peticionados, ya que la Comisión tiene el privilegio en el proceso ante esta Corte de abrir la audiencia mediante el abordaje de las razones que la llevaron a someter el asunto ante la jurisdicción contenciosa de este tribunal, como así también de tener la última palabra en una construcción pretoriana que no se basa en disposiciones estatutarias, sin que el Estado y los representantes tengan oportunidad de replicar sus argumentos. Entonces, ¿no sería el momento que esta Corte requiera alguna explicación a la Comisión acerca de las razones de su por lo menos extravagante proceder procesal y en particular las bases jurídicas en las que aparece irrogarse el derecho de literalmente secuestrar un informe de fondo a la espera quizá de mejores condiciones políticas, ideológicas o de otra índole para dar a luz una decisión
que por un mínimo de respeto a la dignidad que hace a su alta función y sobre todo al derecho de las presuntas víctimas a conocer de esa decisión y al derecho del Estado a ejercer una debida defensa, debe hacerse en tiempo y forma. Está en juego, señora Presidenta, ni más ni menos que la legitimidad, credibilidad y oportuna justicia internacional que se espera en el sistema interamericano de protección de derechos humanos. Desde ya lo dejamos peticionado y sería de suma importancia que la Comisión pudiera explicar esta situación. Yendo al caso puntual y antes de adentrarme a la cuestión de fondo, no queremos dejar de pasar por alto que hay una excepción preliminar interpuesta por incompetencia ratione materia y que debe reiterarse su procedencia en tanto se consideran que deben ser desestimados aquellos hechos presentados por los representantes de las presuntas víctimas en su ESAP que no integran el marco fáctico del caso fijado por la Comisión en su informe de admisibilidad y fondo número 30 del año 23 y la nota de elevación al presente caso ante esta honorable Corte, tales como lo mencionado como persecución al peticionario, en el que los representantes refieren a una serie de supuestos hechos que se habrían desarrollado con posterioridad a la destitución del juez Moliné O'Connor, como una denuncia penal caratulada Moliné O'Connor, Eduardo José Antonio sobre enriquecimiento ilícito y luego sobre la enfermedad padecida por la supuesta víctima con una serie de acontecimientos familiares sucedidos a lo largo de los años como para vincularlos casualmente con la destitución de su cargo como juez de la Suprema Corte. Sabemos de las vicisitudes por las que tuvo que transitar la vida de la familia Moliné O'Connor, del lamentable deceso del ex juez y de su hijo. Lo que estamos cuestionando es la relación causal que no se encuentra probada en los hechos y que no formó parte de la petición y de lo decidido por la Comisión Interamericana. En función de ello, de acuerdo con la jurisprudencia de esta honorable Corte, este tribunal no tiene competencia respecto de aquellos hechos incorporados al ESAP que no forman parte del marco jurídico fijado por la Comisión en su informe de admisibilidad y fondo, por lo que la Corte debiera desestimar in limine todas estas presuntas consecuencias jurídicas y sus correspondientes pretensiones reparatorias, como ya forma parte de la jurisprudencia de esta honorable Corte. Perdón. Esto como excepción preliminar y consecuente en el momento de fijar las eventuales reparaciones que la Corte decida, requeriremos que esto no sea tomado en consideración y que se sigan los estándares de equidad a las que nos tiene acostumbrado la Corte. Confieso que tenía yo preparado un informe de una naturaleza distinta a la que vamos a concretar en el día de la fecha, dado que las audiencias testimoniales celebradas durante la mañana, fundamentalmente la vertida por el ex ministro de la Corte Suprema de Justicia de la República Argentina, el doctor Adolfo Vázquez, ha aportado una serie de circunstancias peculiares, por calificarlas de algún modo, que han ilustrado a la Corte y a todos los aquí presentes sobre el marco en el que se desarrollaron ciertos acontecimientos que tienen que ver con la petición formulada por las víctimas. Debo aclarar también que desde el inicio el Estado ha mantenido una postura contraria a la pretensión de las víctimas y el principio de continuidad de los actos jurídicos de los Estados me hace funcionalmente obligado a ajustarme a esos parámetros. Pero durante las audiencias del día de la fecha me parece que es necesario contextualizar lo que pasaba en nuestro país. Sé que fue objeto de reiteradas y repetidas preguntas por parte de los magistrados. Interpretamos que con esa intencionalidad, y no sé si se logró llegar a esclarecerlo en debida forma. El país allí por el año 2001 atravesaba por una profunda crisis económica, donde se empezaron a tomar estas decisiones conocidas, como decía el doctor Vázquez, como corralito primero y corralón después, y las decisiones que fueron dictando los jueces de la Suprema Corte de Justicia de la Nación en pos de defender la integridad de los depósitos realizados por los particulares, por defender el derecho de propiedad. Todas estas cuestiones de la asimetría de las prestaciones y la defensa del derecho de propiedad vienen marcadas en estos fallos y que tienen que ver con el fallo Smith y el fallo San Luis tan mencionado en la audiencia de hoy. Se hizo mucho hincapié en el tema de las mayorías automáticas que se le indilgaba a algún grupo de integrantes de la Corte Suprema de Justicia de la Nación para la toma de algunas decisiones que no tiene que ver en criterio con esto que se está debatiendo en el día de hoy. Esas mayorías automáticas estaban más vinculadas a las decisiones adoptadas supuestamente para aquellos que hacían ese tipo de elucubración, con decisiones adoptadas por la Corte Suprema de Justicia de la Nación en cuanto a la constitucionalidad o no de determinadas decisiones adoptadas durante el gobierno del presidente Menem. Aquí cuando se empezó a cuestionar el funcionamiento de la Corte Suprema o los votos que dictaban los distintos integrantes de esta Corte Suprema tienen que ver con esta cuestión de la especificación de los depósitos en moneda extranjera o no, y no quizá con esa mayoría automática. Me parece que eso tenemos que contextualizarlo debidamente. Lo mismo en cuanto a que lo que determinaba la ley 24.018, que tiene que ver con la jubilación de los magistrados del Poder Judicial de la Nación, y que no sé en los distintos países de los que ustedes provienen cómo es, pero en la República Argentina es un sistema en el que he reunido determinados requisitos que tienen que ver con una cuestión etaria y una cuestión de aportes previsionales. La ley le da la posibilidad a ese magistrado de presentar, acogerse a beneficio jubilatorio y que se le otorga y queda supeditado a la presentación de su renuncia efectiva al cargo. O sea, pueden pasar varios años entre el otorgamiento de ese beneficio jubilatorio y la real percepción por parte de ese magistrado, porque queda diferido en el tiempo a la renuncia a su cargo. Esto entiendo que, y también me parece que es un tema para controvertir con los peticionarios, eso le daba un derecho en expectativa, pero no un derecho adquirido. Cuando la ley 24.018 establece en su artículo 29 que se dispone que no deba abonarse el haber jubilatorio si el magistrado es destituido por causal de mal desempeño, probablemente sea, como decía la doctora Cecilia Moliné O'Connor, un tema de modificar o no la ley, pero era la ley que estaba vigente. Y así lo dijo la Corte Suprema de Justicia de la Nación Argentina en un fallo del mes de octubre del 2024, cuando rechaza la petición de que se le concedan los haberes jubilatorios y, por ende, queda atada la suerte de la pensión que pudiera corresponderle a la señora Susana Rita Almeida, la cónyuge del juez Moliné. Me parece que esos han sido puntos sobre la que ha versado algunas de las preguntas de los señores jueces y me parece que correspondía aportar alguna idea para esclarecer la cuestión. Aquí de lo que se trata es, ¿se cumplió formalmente con los requisitos constitucionales para la destitución del juez Moliné O'Connor? Formalmente, sí. Formalmente no hay discusión con esto. Se cumplieron con las pautas establecidas por la Constitución Nacional. La conformación de la comisión acusadora, la comisión la Cámara de Senadores como órgano de juzgamiento. Eso es lo que establece la Constitución, y por el voto de 45 senadores a favor y 19 en contra, se destituyó al juez, y como se puso de resalto en esta audiencia, no se le agregó a esa destitución la causal de la inhabilitación para el ejercicio de cargos públicos. A partir de ello, el tema jubilatorio y de pensión corre de la mano. Entonces, en lo que es de lege ferenda, se han cumplido con las pautas constitucionales y legales establecidas por la legislación.
Established by the Constitution and the other laws in our country. Regarding reparations, I understand that we will wait for reparations if the Inter-American Court decides this following the standards of equity we are accustomed to. The court has also mentioned that the system and the national constitution of Argentina is adequate to the standards. So we need to take into consideration as well the establishing of those reparations. That's all we have to say, honorable judges. Thank you so much to the representation of the state. Following, we'll have the representation. We can hear the rejoinder of the alleged victim. Well, thank you very much. We have 5 minutes. We're going to try to be brief and answer all the questions. First of all, regarding incompetence. The facts are aligned with the merits report. There are also rulings that can be added. This morning, I think
the merits.
The violation of judicial guarantee didn't end in 2003 when the court ruled. That was violated later on because after that the pension was removed. Legal proceedings were started. Everything was mentioned this morning. All the harassment, the persecution of the executive branch on a judge from the Supreme Court didn't end there. That didn't end in June 2003. That's why we believe that the incompetence exception should be denied. It shouldn't be a previous exception, but since it is in the merits report, it should be allowed. And I wanted to also mention that the state states that there was a violation of all guarantees, and also, and above all, the vote at the Senate and the cause or the decision was limited to the senators to raise their hands, and with a simple majority they decided without any explanation why the conduct of Dr. Moliné O'Connor was considered as poor performance, and they were able to remove a judge from the Supreme Court of his position, and they were able, they succeeded as in other judges to resign.
Entonces fue un cumplimiento formal de las reglas jurídicas,
So
carente de toda, digamos, justicia.
there was a lack of justice and violating all the guarantees that the Commission highlighted and that we also highlighted, and related to the pension. So if my father would be alive today and all the violations would be admissible, he should be back in his position, and he should have that retirement pension. If the case is invalid, then the right of his pension is reestablished. The law is like a menace to the judges. If the judge is threatened with malperformance, then many of the judges will resign. We are here to try to get the reparation of the fight that our father did, and so that this court will do the same as in Peru, Venezuela, and Ecuador, that to protect the state has a right of rejoinder. Thank you, Madam President. Regarding the statements on the representatives of the alleged victim, we do not agree that this should be in the merits report. What we're saying is that on the perspective of the Argentinian state, it should be included, and it shouldn't be included.
Estos son agravios autónomos donde se pretende que ciertos hechos posteriores a la institución de las presuntas violaciones que se alegan en este juicio.
That these violations in the trial to the family, the judicial cause for a legal cause, family history that happened with Dr. Moliné O'Connor, the cause, the link to what happened in Switzerland. This doesn't justify the removal of Dr. Moliné O'Connor. The legal causes and arguments the representatives of the alleged victim would given responsibility to the Argentinian state. These are afterwards, after the removal. These are autonomous that have to be dismissed by the court in the merits of the international commission, they lasted 22 years, so they were able to do a great report. This is an event that's not scandalized because we support the court, and it cannot be understood that the court retain this report without notifying the parties, and to close the faucet according to its convenience. How Inter-American Court can do this regarding to this are the arguments that we wanted to pose, that this is this may proceed, and we believe that this can proceed. Thank you, Madam President. Thank you. Next, the representation of the Inter-American has the floor. Thank you very much, Madam President. Yes, the Commission will carry out it in 4 parts. It will refer to the previous things that happened, to the notification of the admissibility and merits. And it'll talk about what was posed by the state, and then the merits, and to the reparation. And the Commission has had much productivity, that they may be presented in a chronological order and in an orderly way, and to allow its attention. In 2023, the admissibility of fund, there were 3 merits report that were prepared. 23. The periodic reporting of the reports allowed that the states, so that we make the recommendations for the Commission to the follow-up up to the term established, and compliance with the recommendations. The Commission, in its annual report in 2024, to give provision, the Commission would adopt the parties when they, so that the states and the petitioners would have knowledge of these, and it will be predictable. And if the voluntary of the state for the notifications to be consecutive, we will take note of that. On the preliminary session, the Commission reiterates in all its terms the written recommendations presented by this court in May 25th, 2025. The state said that the court does not have competency in the area to represent events that the victims perform in their report that does not form up our legal framework. That this is not an exception, because it doesn't question the competency of the court, but the factual framework. The civil court needs to decide on if the procedure is accepted regarding the parties, to see if these are related to the factual framework of the case. The representation of the victims, what's recommended to the legal causes, would be where his removal and the suspension of his retirement, and his death would give additional elements to establish justice regarding his lifelong pension. And the court should determine this. Regarding the merits, the Commission had said that based on criteria of discretionality or political convenience, it needs to exist within a legal control, in control of the principles of legality and due diligence of the legal process. And this was confirmed by the court in Rios Avalos versus Paraguay by the court, where the independence guarantee says that using impeachments against judicial employees is in charge of the bodies to review these or the content of the decisions given by those authorities. Precisely, this is what happened in this case. The Argentinian state suspended and removed Mr. Moliné Connor as a judge in the Supreme Court of Justice because of a cause that the judgment he gave in the Mueller case. Now, there are four aspects.
First,
Yes.
judicial independence. Second, the right to have an impartial authority. Third, the right to judicial protection. And fourth, the revocation of victims' lives pension. Regarding the first aspect, judicial independence, the principle of legality, and the due motivation, the state alleged that the process of removal of judges complied with international standards and that the removal of Mr. Moliné fully respected the principle of judicial independence and the guarantee of stability and irremovability in judicial office. This did not occur in the present case as detailed below. First, the Commission recalls that the cause of poor performance of duties, which was invoked to remove the victim, is only provided for Article 53 of the Political Constitution. This clause, which was never regulated or developed by a special law, is extremely vague, giving a wide margin of discretion to the sanctioning authority in charge of applying it, which is the Congress, and offers few guarantees to the magistrates who cannot guide their conduct according to clear and pre-established parameters. The Commission notes that the vagueness of the grounds invoked made it possible for each of the chambers of Congress to consider as facts constituting poor performance in office a series of jurisdictional decisions issued by Mr. Moliné O'Connor as Supreme Magistrate, which corresponded to his judgments or legal criteria and which were protected by the principle of judicial independence. Thus, given the absence of clearly established conduct in which the complaint filed against the victim could be subsumed, or the criteria of interpretation of the constitutional norm, on the one hand, the Chamber of Deputies understood that it had to analyze the judgments in which the victim participated, and on the other hand, the Chamber of Senators attributed to it that through its legal decision, it judicially legitimized a fraudulent administrative process and arbitrarily abdicated its responsibility to carry out a constitutional control over the case. Second, in October 2003, Mr. Moliné was preventively suspended from his position without pay pursuant to Article 4 of the Senate regulations, despite the fact that there was no rule establishing the possibility of suspending magistrates. Said authority considered that since it was already empowered to order a more serious measure, such as a dismissal, it could suspend him in order to prevent the administration of justice from continuing to be affected by his actions. However, the evident restriction of the principle of judicial independence and the guarantee of stability of the victim, it was incumbent upon the Senate, in addition to respecting the principle of legality, to adequately substantiate the legitimate purpose it intended to achieve and to demonstrate that the suspension was suitable, necessary, and proportional means. Third, the Commission recalls that by virtue of the principle of judicial independence, the organ or organs involved in the processing, deliberation, and resolution of proceedings against judges are prohibited from reviewing the grounds or content of the decisions issued by such authorities, with the exception of intentional violations of the legal system or proven incompetence in office. Contrary to such standard, and as was narrated this morning by former Justice Adolfo Vázquez, the dismissal of Justice Moliné O'Connor was decided due to his legal reasoning issued in the so-called Meller S.A. case. Thus, it is not identified that the Senate had duly substantiated to what extent the legal grounds used in the resolution adopted by the Supreme Court in the aforementioned case had constituted a truly serious conduct of the victim. In this sense, although Mr. Moliné's defense argued that such decision only followed the jurisprudence of the Supreme Court of the nation regarding the admissibility of the appeals, such argument was not analyzed or answered by the Chamber of Deputies or the Chamber of Senators. Likewise, the opinion of the impeachment committee of the Chamber of Deputies focused mainly on the economic damages derived from such a decision, without clearly explaining why the legal criterion of Mr. Moliné O'Connor constituted an intentional violation of the legal system or a proven incompetence that, due to its seriousness, would have compromised his suitability in office and therefore justified his removal from office.
In relation to the second point, the right to an impartial authority, the Commission recalls that in the case of Apitz Barrera et al. Versus Venezuela, the court established that recusal is a means to protect the right to be judged by an impartial body, since it allows the removal of a judge when there are demonstrable facts or convincing elements that produce well-founded fears or legitimate suspicions of partiality about his or her person. In addition, in the Rios Avalos versus Paraguay case, it recognized that although our agreements and consensus at the political level can be effective mechanisms for decision making, when there is a possibility of affecting the principle of judicial independence, the subjective impartiality of the body in charge of the proceeding is essential. In this case, the right to an impartial authority established in Article 8.1 of the American Convention, as long as the impeachment didn't have a specific process before the Chamber of Deputies and or of the Chamber of Senators. The lack of regulations meant that all the recusals filed by the victim during the impeachment trial were rejected without any legal grounds. On the third point, the right to judicial protection, the Commission recalls that the victim judicially challenged both his suspension and removal as a magistrate, but the judicial remedies resolved by the Supreme Court of the nation did not provide an effective judicial analysis of the alleged violations of the rights enforced. In the first place, on June 9, 2004, the Supreme Court partially rejected the alleged victim's claim regarding his suspension, limiting itself to affirming that the Senate was competent to adopt such a measure, that it was only unreasonable with respect to the suspension of his salary. Thus, said body only analyzed the reasonableness with respect to the deprivation of remuneration, without examining the legal basis and due motivation for the suspension of his position. Secondly, in its decision on June 1st, 2004, the Supreme Court argued that the configuration of the cause of poor performance that the Senate considered to have been proven could not be reviewed in the judicial proceeding, thus declining its competence to evaluate whether the dismissal of Mr. Moliné O'Connor had sufficient legal support in order not to affect his rights and the principle of judicial independence in the framework of the lawsuit filed by the victim. Thirdly, in the aforementioned judgment of June 1st, 2004, the Supreme Court decided not to analyze the specific arguments presented on the violation of the right to an impartial judge due to the systematic rejection of the recusals filed by the victim. The Commission therefore considered in an impeachment trial, this guarantee could lead to a disintegration of the judicial body in accordance with its legal decision. Therefore, the Commission's opinion, Mr. Moliné O'Connor did not have a judicial pronouncement analyzing the reasonableness of the measures imposed against him, which meant that he didn't have true access to justice. Regarding the fourth aspect, revocation of the victim's life pension, the Commission recalls that this decision, taken by the Ministry of Social Development in October 2004, was challenged administratively and judicially by Mr. Moliné. Thus, on April 15, 2013, the Third Chamber of the National Court of Appeals for Federal Administrative Disputes ordered the proceedings to be suspended until the petition filed before the Inter-American System was resolved. Subsequently, in 2013, the Third Chamber of the Federal Contentious Administrative Chamber decided to restore the life pension and ordered to pay the unpaid sums of money plus interest. However, the victim's next of kin reported that neither Mr. Moliné during his lifetime nor his widow after his death received any payment whatsoever. The Commission notes that the judicial process aimed at achieving the reinstatement of the pension took approximately 9 years. and that between April 2011 and October 2013, the process was suspended under the excuse that there was a petition on this matter in the inter-American system. This argument is inadmissible and does not justify the suspension of the process, since the filing of a petition before the Inter-American Commission does not exonerate the national authorities from complying with the adequate and timely resolution of the cases. Furthermore, although the process was not a complex one, since it was a strictly legal analysis, this delay meant that the victim was unable to receive her pension, which affected her quality of life and her right to private property. Finally, the Commission reiterates the measures of reparation established in its merits report, including the measures of compensation and satisfaction for the next of kin of Mr. Moliné O'Connor. Honorable Court, the present case illustrates the way in which the state, through various institutions and mechanisms, affected the principle of judicial independence that protected the victim in his capacity as a judge of a high national court. In this sense, the judgment issued by this court will allow us to continue strengthening the guarantees for the independence of judges of high courts in our continent. Thank you very much. Thank you very much. The Inter-American Commission, my colleagues asked if there are questions from my colleagues. Yes. Thank you very much, Honorable President, for questions for the Inter-American Commission. I understand that you, correct me if I'm wrong, you allege that one of the judgments from this impeachment invoked is Article 53 of the Argentine Constitution, which talks about poor performance. With this not being a regulation, through a law that would be adjusted to in the strict sense to legality. Is that the argument? Yes, Mr. Judge. The conclusion of the commission was that there's a responsibility because of Article 9 of the convention, particularly the principle of legality, because the way in which the constitutional disposition is posed is very open and allows that the discretionality of the authorities, legal authorities, or the authorities of the Congress can apply arbitrary measures. So it means that they wouldn't have the legal safety to proceed and to know in what cases it could be sanctioned. What countries, thank you, Doctor, what countries in the region have this type of legislation that develop a constitutional clause of this type? Are there experiences that you may share? A constitutional clause that at this moment would have, I don't have information, but there are more specific legislative matters to allow one to establish these, what dispositions, yes, of the maximum court, yes. Could you share this with us? Yes. Yes, we can contribute this, of course. Thank you. Another question for the commission. In light of what we have listened to today, and I'm not speaking of the allegations done by the state referring to facts that would be out of the factual framework, which would not be in the merits, but I'm talking about what was talked about today in the hearing. And I would like to ask, is the reason for not including the violation of some rights, such as the ones that are in Article 5, like the fireworks that were, and the social rejection, and it's also were mentioned Article 11, the protection of the family. Perhaps was this considered by the commission, and what would be the reason for that? Thank you, Mr. Judge. regarding what is indicated by the inclusion of certain dispositions of the laws in the commission at the moment of doing the analysis, specifically of the admissibility and the merits of the case. It didn't have specific information regarding everything that was mentioned today relating to how the victims were affected, the personal integrity, to the honor or to the dignity, or their private lives. That's the reason why there's a legal trial that apply type of conclusion. Thank you very much. You've been very clear with your answers. A question for the agents of the state. Here it's alleged that there was no mechanism for recusal. How could it have been done in operations? And if a senator or a deputy was in a cause, you allege that, we'll take out another senator? Is that the argument? Could there have been a alternate senator to replace that one? I'm trying to understand the argument better. I think what Dr. Vasquez said, if there was a system of recusal, of challenging to excuse oneself to be replaced by another senator, was that feasible? No, there was nothing to impede that. Thank you very much. That's very important. Another question for the agents of the state, if I can. I understand this is a direct quote. The response writ that you talk of the practice, you have a very rich constitutional history, more than 150 years, and it says that to consider poor performance remits to the functional performance, and that the judge has to be judged by their legal performance. What is functional performance? Does it mean to see the content of the Supreme Court justice? Do they refer to that, or do they refer to something else that I'm not understanding? Did the Argentine state or the jurisprudence comment off mic? I said that never. Please excuse me, they're going to resolve this sound issue. I said that the judges are not judged by the content of their jurisdictional judgments. Did that happen? According to your criteria? Are you talking of the situation that I need to return, or that what you need to state within a few months? What are you asking here? I'm alleging a position of the state on the year 2023. I could respond more freely. The senator of the nation said that the judge's performance was poor performance. Judge Moliné O'Connor's behavior. I wasn't a senator. I'm not a senator right now. It's very helpful. Thank you. And one last question. I think it's the last question. I'll see if there's another one. For representation of the alleged victims. I would like to maintain a discrepancy in a part of the report of the commission. Do you continue to sustain this up to today at the moment of this hearing? It has to do with the life pension. We are sustained always that the right to the pension. The question is if you maintain that the commission erred. Yeah, I'll say, if I'm not wrong, that the commission has varied its position on the report and says that the state, if I'm not wrong, is responsible for the violation of private property. I think there's no discrepancy there. Perfect. Thank you very much for that clarification. It's a topic that I had doubts on, and I think it's an important one. So if Dr. Baños excused himself to respond to the question, and I understand the motives or the reasons for that, I will now will give the question to you. Could today Dr. Vasquez mention that this wasn't the historical practice of the Supreme Court in Argentina regarding impeachments? There was no background to get involved into the foundations of the judgment. A judge of the Supreme Court to justify his or removal, but that criteria was used for your father? Yes, absolutely. As we said, that my father said it from the first moment on November 17th, 2003, his first complaint on the international level, there was no cause for poor performance in the Mayer case. They had limited this to limit the jurisprudence. 1957, the Supreme Court of Justice that the decisions of a legal case, when the legal jurisdiction is decided, you can't go by the judicial one, because if you decide for arbitration, you can't go back to the courts. So it's to apply the history that the Supreme Court had always applied. There was no cause for poor performance, and we've said always, and today Dr. Vasquez ratified this as a witness, as an in-person witness. The argument was that President Kirchner wanted a change in jurisprudence. Yes, that's clear. I would reformulate the question. What the Supreme Court of having maintained its historical precedent once your father was removed from due to an impeachment, the foundations were used. They got involved with the content of the judgment, and the court ends up validating that. The court validates that, saying that it doesn't have the authority. Justice doesn't have the authority to examine the merits for which the Senate had decided to remove him, under which the principle of judicial independence, from which the judges last in their functions as long as they have good behavior. If a judge applying the jurisprudence they always use, with this interpretation, Article 101 is changed from the National Constitution, the guarantees of the Convention of Judicial Independence, in the sense that the judges last in their position when the legislative branch to the and the executive branch and the legislative branch want it to be so. If the court says we can't review certain things, then what would the defense be? There's no control, and yes, the cause for removal is the legal criteria used. Good afternoon, Mr. Judge. I would like to remind you what the court said on the judgment. No, you don't need to do that. It was very eloquent. Yes, that's why I'm asking the question. Thank you very much. I don't have any more questions.
Thank you, Judge Moreno. Judge Bordea Odria, do you have any questions? Yes, Madam President, thank you. I would like to ask you one first question to the representatives. In the calculations for indemnization, for the retirement pension of your father, there is also a calculation on the salaries that he didn't get until the time of his death. Wouldn't there be a duplicity if the salaries didn't perceive were accepted, then the pension would not be so is one or the other? No, what we have said is not, there is no double amount, but it's like an option for the court. The indemnization can be calculated from the salaries that he didn't get from 2003 when he was suspended up until the time of his death in August 2014. That's one option. Another option, as he already had his retirement pension confirmed and he would start getting that once he left office, then calculation can be done by that as well, without the salaries he didn't perceive, and it's either one or the other. There is no duplication here. It's one or the other. Okay, perfect. Thank you. Another question that applies for you and eventually for the representatives of the state. Dr. Moliné O'Connor, after the rulings, after he was removed, was there a trial on breach of trust? No. I will go by in order because I have some questions. The representation of the state mentioned something that is not the first time that they mention, and probably you have thought about it in the commission. What is your opinion in the commission regarding that the commission shouldn't be the one who has the final word? Because you're not the accuser in the case. Thank you very much, Mr. Judge. What you're mentioning regarding what the Commission does. I tried to explain it at the beginning. The Commission has recognized that due to the limitation of resources, the cases cannot be analyzed as fast as we would want to. And it is important to highlight that there is a criteria of like a timeline. So it is related with the portfolio of each state and the capacity of the Commission to study each case and to study the merits reports and to notify the states. Thank you, but my question is, the state mentioned, that's what I understood at least, that this is not the first time that they mentioned this. The Argentinian state mentioned this, and I don't think I've heard the Commission talk about this. So what is it? We're not talking about the time it takes, that's another issue. But the structure of the system where the Commission promotes the case and exposes the case so that the state can defend themselves, and then in any process where someone is being charged, then the person who is being charged would have the last word as defense. However, the Commission uses the last word when we're at the court. I imagine that since you are looking for justice, justice might be hand in hand with what the state is mentioning. If I'm being charged, I need to have the last word. What do you say about this? I think now I understood your question. Which is related to the way in the public hearing is takes place. If that's the case, there has been several changes in the role of the Commission and how the public hearing takes place in the inter-American system. And the Commission has varied its role, but it is also true that this regulation has been subjected to regulations that depend on the Inter-American Commission. What it is, the truth is that the role in the Commission at the time of this procedure is to make the considerations after the parts have spoken, and the Commission does not have the same role as before as representative of the victims. I think this answers your question. Okay, thank you for your answer. Now you have changed your capacity, and now you are like pre-judges. You give your opinion to the judges. So, because if the two parts have talked, explained, there's something else I want to highlight, that in the competences of the court, the Commission, the function of defense of public order is relevant, so that the Commission talks about that. I will finish with this question, and because I think this is important. I'm starting my position here for the next 5 years. So, in any case, the representative of the public ministry would talk after the defense. So, he or she will be the last one to speak after the defense, because first we have the accusers and then the public ministry. Is that what you're saying? Maybe I wasn't clear. What you're asking right now is derived by norms from the Inter-American Court. The structure of this hearing Thank you very much, Doctor. I would like to ask a question to the representatives of the state. I understand what you say about the continuation of the state, and when the violation happens, the state committed this there is a principle, the principle of continuity, of course. So I understand the difficulty to defend positions in the past. According to what I've heard, the Chamber of Senators did not oblige, or the Congress did not oblige the judges to intervene in the resolution of the conflict. They could continue with the topic. The charges leveled on Mr. Moliné O'Connor were to negate the administrative resolution that was
an administrative manner. At one time, it was demonstrated that those interests exist, because he was accused of that. He was being judged for that. Were those interests demonstrated to be behind the judgment? Did they exist, those interests? Yes, Mr. Judge. Honorable Judge. Yes, the decision that motivated the questioning, as the representative of the petitioner said, to follow the jurisprudence of the court itself. They would opt the decision of an arbitration court to give access to the jurisdiction. And that was the motive of the Miller case. So we're committed to find out if that would be verified, and we'll report back to you. Another question, and understanding the difficulty of being in the previous topic, what been previously established after so much time. It said here that commission of impeachment is not within what is given to the judges of the court regarding final interpreters of the national constitution. It would be good if the judges would be there at the moment of dictating the judgments, the consequences, what was said in their judgments. If, especially regarding institutional relevance, that was Dr. Moliné didn't consider in the causes that motivated this impeachment. So this is not an estimation of a supplantive supposition. It would have been good. My criteria would be better, is what I'm saying. Since you didn't do the best action, then you have poor performance. It's a political determination, or is it jurisdictional? The construction that you're doing is a political one. Yes, political. The construction that you're doing. When I say, I'm quoting the court, what's in the file, but it would be good that the judges of the maximum court would be there at the moment of hearing the judgment. The consequences derived from their judgments. That's why they removed Dr. Moliné. The issue is simply to try to understand the posing, if it's purely political or it's mainly political. Why? Because a question regarding the position of the state, Article 75 of the Argentine Constitution points out as being different from most of the constitutions of the Americas, in which we're seeing the legal system that the treaties of human rights have a hierarchy, even a constitutional one, as they don't dismiss the first part of the Constitution. This isn't the first part of the Constitution. It's the organic part of the Constitution. So, eventually, this is a part that has to respect what is mentioned by the Convention in all cases. Do you estimate that Article 23 of the Convention, the article that refers to political rights of political participation, is not the same of political rights? It says all citizens have to have the same rights or opportunities to have access in equal conditions of the republic of their country, and that law can regulate this. So no one can be
Removed.
Excluded if there isn't a sufficient reason. Does this article apply in consideration of the Argentine state? Because I haven't seen a reference to this specific point. I've seen a reference, and I would, in the best spirit of, please understand me, if we continue to consider the topic of political aspects that cannot be tried. So the judge, judicially, cannot be tried judicially. Does this judge have rights within this article? Yes, the constitutional reform of 1994 is the one that introduces, from paragraph 22 of Article 75, using international treaties to modify in such a way as what's said Articles 30 and 31 of how the national legislative system was entered into, and the matters need to be resolved by conventional mandate if it's in contradiction with a provision of an internal provision. I didn't want to interrupt you, but when you were arguing your question, I think what we need to take into account, the way I see it, is that the Senate of the nation would not admit an opinion of legal nature, but political. It's political. What the judges claim is political. To have a judgment as you need to do, but not ignore constitutional matters that have an institutional repercussion. We need to take those into account, but we place it in a scale of values or in the legal pyramid, the decisions that the judge must make. Excuse me. I understand that the judges are tired with that conventional provision. Yes, it has to be protection, because if somebody participates in the process of tasks of the state to participate, they receive training, but they also are given immunities, or they give the defenses. So stones cannot be thrown at them every day. So here what we need to analyze is that if the one who forms part of the court arrived there with this shield, and if this shield at the half the way there, they took away the shield. Now it's a shield to ask, and it's a shield to answer some things, and a shield to not answer other things. It's from me also. But please understand that political matters are political, according to the moments where they happen. They can be understandable or not. I always will prioritize the evidence of the judge and the judgments made by the judges. I will always give those priority. But looking at the political matters that cannot be judged by the justice system. The political matters that cannot be judged by the judicial system can be divided by sections. So the responsibility of the Argentinian state could not be pointed out for this matter. Does that exist? Yes, in these matters, matters that cannot be judged, that are political, it allows the governance with all respect that I have of you. You're asking for an opinion that we're expecting from you. Yes, there's a central topic that's in Article 29 of the Convention that establishes that when the country itself responds or respects or provides to citizens a right, in this case, public servants with a right, the court has nothing to say. That's an important thing, that the court cannot repeat was already stated by the states, because I think that's redundancy, not yes, I clearly understand the position of what the state has within the principle of continuity response confronting the situation. Thank you, Doctor, as always. Thank you, Judge Borea Odrea. Judge Perez Colbert, do you have any questions? Yes, thank you, Madam President. A question goes to the representatives of the commission, if you could specify what elements you had, that the commission had to understand that the presidential discourse regarding Judge Moliné O'Connor could affect the possibility of the court at the moment that it was judged, or at the moment that judgment was passed. Thank you, Madam Honorable Judge. Give the floor to Ms. Saavedra to respond to this. Thank you, Honorable Judge. The Commission takes into account not only the allocations of the President referring to in the national network, but also the position of members of its political party after that date. We transcribed not only the declarations of the First Lady, but of senators that had manifested or had extended criteria that they coincided with the President's criteria, and also expressing some of the expressions, personal expressions that were referred to. Thank you. The report also took the declarations of senators, including those in the personal order, a specific senator, and that all reflected an intentionality headed by the President that was operated by the members of his political party in National Congress. Thank you. I have a specific question. We've also posed matters related to the eventual amplitude of the case, and to the motivation. If you could briefly describe, and in a precise way, the motivation to right of defense regarding the terms. It's an aspect. I'm referring to elements that would talk about vulnerabilities to the right of defense that the doctor suffered at the moment of impeachment. The constitutional regarding the right of defense, the term to the right of defense. On that topic, the Commission considered the specific law of impeachment. There was a term of 15 days for the defense that could be extended. That could be considered additional in terms of the distance. Dr. O'Connor presented his defense and a written defense, even though alleged before the commission, it was short term. He didn't present other additional evidence to accredit the duration of that term had caused damage to the defense. But he had presented his defense and as in a public hearing. It concluded they didn't have sufficient information that was a specific violation to the right of defense in regard to another element. And the other months of right of defense, the duration of the term was considered, lack of motivation, the extended cause in the rules, and also the recourse of the senators, among others aspects. The possibility to present its defense, no, that was not considered. Thank you very much. A question to the representation of the state. I would like to, if Dr. Baños, I didn't understand that very well when the question that was made of you regarding the cause, or the case, excuse me, the case of the constitutional accusation, which would imply, I will transfer what I wrote, to have a judgment, but not ignore constitutional matters that are relevant. What does that mean in the specific case of the configuration of the for performance? Yes, I said that, doctor. Something, I think it was a response that I gave to the doctor. What the Senate was claiming is that the judge could make a judgment, but he needed to take into account at the moment of the judgment that there could be matters of institutional relevance and what was claimed in this case. That's what the Senate said. Forgive me, doctor. Here it's very relevant and important to have the precise standing of the Argentine state was a cause of poor performance. With the Argentine state is validating and is assuming that the performance was what corresponded. Why? Because there's no type of recognition by the state. Given that the state in this hearing is pointing out that it esteems that the performance of the Senate was formally adequate, an adequate judgment of Dr. O'Connor, Moliné O'Connor. Therefore, I ask, what would be those institutional matters in the opinion of the Senate? Judge Moliné O'Connor didn't have. Therefore, it formally he was judged as having poor performance. And regarding other members of the court, to not open the jurisdiction of the court in cases if the arbitration was appealed, the challenge that not take into account other matters. That's what the Senate considered for poor performance as a political decision of the Senate. So that in the concept of the Argentine state, would it be would it be involved in the judgment? The Senado said that there were poor performance because the judge didn't take into account an economic repercussion that the judgment would have. So I ask you, if the Argentine state does it sustain that type of qualification, take into account the judicial matters? That's what the Argentine state said. That's what we heard. What I answered was that there was always a criteria that judges should not be scrutinized under analysis, but because of the content of their judgments. That's a content of Argentines that I've depended, and legal counsel has systematically defended this. What doctor said was, and the Senate, as recommended by the accusing commission of the Senate when it issues the sanction, is that this is non-compliance of the mandate, poor performance, because it didn't take into account institutional repercussions that its decision could have. That was a decision that adopted by the Senate at that moment to justify the removal of Judge Moliné.
I understand, but don't answer with questions that my colleagues already asked you. I'm asking something specific. You are here saying the position of the Argentinian state. We know our role, you know your role. So the question is the following. For the Argentinian state, the fact that a judge does not take into consideration the economic repercussions of a decision, does that constitute a legitimate element from the Senate? I know what the Senate said, we've heard it, but what is the position of this Argentinian state. And why do I ask this? Because in this hearing, you say you validate the actions of the Senate. So for the Argentinian state, is that a valid interpretation? That the judge sees the economic repercussions for the government? And please be concrete. The Argentinian state has sustained that through all the presentations in this process, the continuation of personally, I think it does not correspond. Thank you, doctor. And lastly, very concrete and very specific question. Regarding the removal of the retirement pension, so that we can understand the context. It has been said here, and you've heard, that one of the reasons that the other judges, by which the other judges resign, is it was not to lose this pension. What is the position of the Argentinian state on that information? I heard that today, after what Dr. Vasquez said, I understand that for personal reasons, due to physical conditions, and maybe others due to because they knew that they will be removed, and which will leave them without this pension. But I'm answering this with what I've heard today, that the reason was that the result of the impeachment will be the removal, then they decided to resign. So thank you, doctor, and taking advantage of your experience as a former judge of Argentina, is it normal that in Argentina, when there are conflicts of interest in this type of proceedings, there are no recusals, but when there is a conflict of interest, we've seen that the president at that time decided to do this, to perform this type of trial, and the wife of the president was the head of the commission. Situations of that nature or similar, is it normal that nothing happened with this type of situations? Because this recusal happened and there was silence. It wasn't resolved. Because since we're not Argentinians, is this something normal that happens in Argentina? No, it is the trial of judges of the Supreme Court is not something normal. Right now I don't remember others. If there was a conflict of interest, should have been solved. The former senator should have excused herself, or the recusal should have been performed. So I understand that there were no elements in the Senate to deal with this situation, but sometimes the Praetorian right is what rules. And thank you, doctor. No further questions. Thank you, Judge Perez Goldberg, Judge Manrique. Yes, I have short questions to make. I will ask the representatives if you can make a summary of the arguments by which you say that there was a removal of this life pension. Can you make a summary of your arguments?
Sí. Bueno, la cuestión es decir, la ley 24.018
Law 24,118 of pensions of Argentina states that in the case of judges, if there is an impeachment due to poor performance, they lose their pension, their retirement pension. That is the legal cost. My father had already gained this pension in 1998 because he had all the legal requirements from that law, which are several requirements, like the amount of years worked and so on. So the Secretariat of Social Development had already granted him that pension, and it was an acquired right. What was needed only that he would stop working as a judge of the court and would start getting this pension. When the removal via impeachment happened, in 2003 he was removed, and he wanted to make use of the pension, but there was a resolution from the Secretariat of Social Development which stated that the Secretariat revokes this resolution that was passed 5 years ago. So this right was repealed. The judge was living under threat, and I think that the other judges would have not resigned. Telling a 65-year-old man, telling them that you're going to lose all of this pension, it's impossible. They should be allowed to face these attacks with the economic means necessary. But what happened here is that the violations, they invalidate the removal.
ese derecho es
So,
diferente. Si mi padre
if my
viviera
father
y
would be living today
la reposición de su cargo,
and
naturalmente nadie podría decir usted vuelve a
he
ser
would get
conductor
his
porque no
position,
tiene derecho de jubilación.
he
Entonces, el
would
derecho de la
be a
muerte
judge
no
again.
puede, digamos, simular ese
Then and then he passed away, he would get this pension. There is another argument. There is a constitutional norm. Eduardo, you can remind me of that, maybe, which states that in the case of impeachment, the only effect of impeachment is removal. This norm that is inferior of the law to the law this contradicts the Constitution because it states that the only effect of impeachment is the removal of the position. So there is an inferior norm that surpasses the constitutional norm. Thank you so much. Do you want to add something else? Just to clarify, there were two arguments here. On the one hand, there was an acquired right due to the pension that was acquired or granted beforehand, and then it was removed because there was an illegitimate removal. So we have two arguments. Is that correct? Yes. I will ask the same question to the state, because you mentioned this law and you talked about acquired rights. And I would like to know what's the concrete situation or your concrete position regarding this matter. What we say is that Dr. Moliné O'Connor had a right, an expected right. As the petitioners say, it was granted, but there was a condition. If he resigned or removal, Article 29 says if the cause of removal is poor performance, then the pension does not is not granted. And that also is affected to affect the pension of the wife. Yes. Yes, that is clear. I have another question. I've listened to all the answers carefully. On the topic of the impeachment, and at some point you said that you understood that the impeachment had all the constitutional requirements, fulfilled all the constitutional requirements, but on the other hand, there were other statements related to senators that accepted the recusal, and that there are no previous what I want to pinpoint is that the This is not clear from my point of view. Uh, it, this is just a comment, it's not a question in itself. I just want to hear the state's position on my statements. With the respect I have for you, I am in a position that I have to defend the state's interests. If I would have been in that table, the answers might have been different. Yes, this is clear. I just wanted to hear it from you. I have no further questions, Madam President. What I want to ask to the Inter-American condition, the article regarding Article 9, because it is difficult to imagine how can you typify in any way the cause of poor performance when that's why the court has adopted the position regarding sanctions of judges that due to that the particular specific nature, or when we talk about violations on Thank you for your question, Madam President. We can clarify the position of the Commission, Inter-American Commission, in their merits report. It is related to several factors. The first one related to the way in which the literality of the norm, but also other factors that generated the victim was sanctioned. So it's not due to the vagueness of the context. Yes, it's both. There was a wide norm that would open the door for discretionality, and due to that, some rights were violated. And the position should be a specific regulation of conducts, because there are different levels of requirements. And another question for the Commission? The impeachment has a jurisdictional nature or political. Thank you for your question. The Commission knows about the impeachment processes, and what it has said is that the dispositions should be guaranteed from Article 8. Those apply to the proceedings because if a political authority can apply these measures, that is a contradiction, because you understand that this is political, but on the other hand, the process is jurisdictional. So what are the essential guarantees? Because if we apply everything from 8.2, we are confirming its political nature. Thank you, Madam President. Regarding the contradiction you're mentioning, this is derived from the nature and the Commission we can definitely delve into more details, so to clarify your question, and I would appreciate that, because this is a key factor in this process, and we need to take care a lot on just generalize Article 8 is not enough. So what are the essential guarantees that this impeachment should have derived from Article 8? Because there are some of them that would not apply completely. Thank you so much. And in your final arguments could also refer to these points. This court has no further questions. Before adjourning this public hearing, I would like to recall that in accordance with provisions of the 13th operative paragraph of the resolution of the President of the Court of August 11, 2025, the representation of the alleged victim, the state, and the Inter-American Commission have a non-extendable period of time until October 27, 2025 to submit their final written arguments and final written observations respectively in relation to the preliminary objection and this case. Finally, I would like to thank the representation of the Inter-American Commission on Human Rights, the representation of the alleged victim, and the representation of the state of Argentina, and the participation in this hearing. The appearance and participation in this hearing. This session is adjourned. Good afternoon.